Welcome to Affluence and Advocacy, NY Real Estate Law.
Hi, everybody. Welcome to Affluence and Advocacy, New York Real Estate Law with Natalia, Shishodia. I'm Matt Sky, and today we're diving deep into the complexities of ancillary probate. Natalia Shishodia, an experienced attorney in New York City, focused on real estate, business law, estate planning, and taxation. She's highly recognized for creating individualized legal solutions for her high net worth clients worldwide. Let's explore ancillary probate and how it can impact you and why having a skilled attorney is so crucial. Natalia, thanks for joining.
Thank you, Matt, for being with me today here.
So I don't know if I've heard that term. What is ancillary probate and how does it differ from the primary probate process?
So I would say that while primary probate is the main event that happens in the jurisdiction where deceased live, ancillary probate kicks in when they own property either in another state or another country. Just imagine a UK investor who lives in UK, dies in UK with a will, but also have an investment property. For example, his pied-à-terre. It can be condo apartment in New York. When this UK resident passes away, his assets will go through the probate. So first, they're going to be a probate process in UK. And then once the final decree is received through the regular probate, we gonna apply for ancillary probate in New York, United States. That is where ancillary probate actually comes in, assuring that our client's pied-à-terre in New York is properly handled under the New York laws and it is given to his loved ones according to his UK will.
So in what situations might ancillary probate be necessary, particularly when the descendant owned property in more than one jurisdiction?
Again, as I mentioned, there could be two cases, right? We deal with ancillary probate when we have a decedent who is a U.S. resident, but somebody, for example, who lives in another state and passes away in another state, or when we deal with foreign nationals who actually live in another country, they have a will in another country, they pass away outside of the country, but they own properties in New York. So, for example, picture a grandmother who splits her time between cozy New York apartment and charming villa in LA. She passes away in LA, leaving properties in both states. So while the primary probate process is in California, where she actually spent most of her time living, and her main probate is going to be handled by California estate and probate attorney. Our firm is going to handle the ancillary probate in New York. And to start ancillary probate, we're going to wait for her California probate to be completed, get the final decree from there, and then we're going to initiate the ancillary probate in New York. So then her heirs can inherit the apartment that she owned in New York.
So can you detail for us some of the complications that can arise during the ancillary probate process?
So actually, that's a good question because ancillary probate can get really complicated. So one of the main complications is navigating different state laws when it comes to ancillary probate. For U.S. citizen, for example, living in another state, it may even feel like trying to speak another language. But because each state, for example, has its own probate rules, has its own probate forms, and has its own deadlines, right? Another issue is coordinating between the courts in different jurisdictions. That can delay the whole process. It becomes even worse when somebody passes away in the middle of real estate transaction. When we are trying to sell something, then we get stuck. It gets more complicated when we deal with a foreign national and when we do ancillary probate. For example, the same example for a UK national who lived in UK, passed away in UK with the UK will and with assets in New York. So we may have to, actually with UK, it may be less complicated because of the same language, right? English is official language there. It would be more difficult when we deal with China, for example. Need to have the documents translated, all originals to be copied and copies to be certified. And we will need to collect the apostilles also for all official documents. Then notifying the heirs can get complicated when we send notification to heirs. We may even have to hire an investigator for geological research. So he would help us to put together a heirship affidavit that we would need to submit to the surrogate court as part of our ancillary process, ancillary probate procedure. So, those are the main things that make it more difficult than the regular probate process.
So, Natalia, how can potential delays impact heirs during the ancillary probate process?
Delays in ancillary probate can usually be very frustrating for the heirs. They may find themselves in a limbo, unable to access or sell out-of-state property, which can lead to the financial strain, especially if they don't have funds to pay for carrying charges, right? Like, for example, for condo in New York, they don't have funds to pay taxes or common charges, right? And it can create a risk, for example, of a tax lien if taxes are not paid for a year. Imagine they would be waiting for a month or even years to finalize the transfer of their family vacation home, or while maintaining it and, paying taxes and other possible carrying charges. These delays can be burdensome for the family. So I can give you a very good example here how, delays create a problem for the client. I was working with two sellers on the sale of their condo apartment in Brooklyn when the husband died in the middle of the sale. He also happened to be a California resident at the time, and his death happened in California as well. So even though husband didn't have any assets in California, by law, his estate had to go through probate in California first before we could start ancillary probate in New York. So it was a sale, and the sale of the condo got stuck because the couple actually purchased it when they were not legally married, and thus they held the title as tenants in common. So the husband's share didn't automatically pass to his wife on his death, but it rather passed to his estate and was governed by the will. So to finalize the sale, we had to complete California probate first. That was handled by California attorneys, and then initiate ancillary probate in New York.
So there's no question this is a lot to navigate. Why is it so important to have a skilled attorney during the ancillary probate process?
Having a skilled attorney is like having a seasoned guide through the dense forest. An experienced attorney can navigate the complexities of different state laws, ensure that all the paperwork is correctly filled, and represent the heir's best interest in the court. Also, when we've seen a lot of cases and we deal with the next ancillary probate, we can tell the client, yes, we already dealt with the situation before. We know exactly what documents need to be collected, so we can be more proactive to help the client. Also, expertise is crucial in avoiding costly mistakes and delays, and it can help client to keep actually legal bill down when we charge by hour.
What are some practical tips you can provide to simplify the ancillary probate process?
So a seasoned attorney usually can streamline the process by coordinating between the primary and ancillary probate courts. Again, like I gave you an example, we work as a team with other probate attorneys from different jurisdictions. So communication would be the key here. Also, in addition, the knowledgeable attorney would ensure that all necessary documents accurately prepared and timely submitted reducing the risk of rejection or delays. For example, I just had a case where a client came to me. Again, I didn't start that probate from the beginning. A client already was in the process with another attorney for 3 years. Nothing moved. We stepped in. We found the mistakes in the application. We immediately started communicating with the surrogate court. And 4 months later, my client got a letters of testamentary authorizing executor to distribute the assets to beneficiaries. Additionally, knowledgeable attorney represent best interest of their clients, providing them a peace of mind, comforting them in the most challenging time, because like in most of these cases, it's important not to be just a professional, like trust and estate professional. It's also important to be a human being, because, we deal with other humans, they just lost a loved one. So it's very important to listen to your client. Sometimes, your client may start crying. They just went through trauma. They lost a loved one. So it's important to be not just a good trust and estate professional, but also to be a good psychologist and to be a very compassionate person who cares for your client.
Yeah, it's a great point. This is a very human business in that sense. So as we wrap up, what pre-planning strategies can minimize complications during ancillary probate?
Simplifying the ancillary probate starts with being proactive. And usually, pre-planning can be a game changer. So we start discussing these issues with the client and inception, when foreign investor just comes to us with the idea to purchase a property, for example, in New York. And they come in from different jurisdictions, right? So one of the strategy is to create a trust. For example, for domestic clients who live in the United States, but maybe out of state in different states, it could be a revocable living trust that becomes irrevocable on death, that can help bypass the need for probate altogether. Or for foreign national clients, it could be irrevocable trust that can serve the same purpose and help to bypass the need for probate altogether. In addition, irrevocable trust would, for example, help clients to avoid probate tax, especially for foreign nationals where the exemption is only $60,000, which is like nothing, So again, planning is essential. Planning is important. I would suggest to start planning asset protection and start thinking about it before even investing in New York, before purchasing. So the earlier you start planning, the better. And of course, consulting with a knowledgeable real estate tax attorney to review and possibly update your estate plan can also address potential issues. And get on board all type of professionals as possible, like to get on board tax attorney, get on board real estate attorney, get on board CPA, other professionals that may be involved in a real estate transaction, like property insurance advisor or financial advisor or mortgage banker, right? If client is looking to finance the investment.
Thank you, Natalia, for shedding light on the intricacies of ancillary probate. For people who want to learn more, Natalia, where can they find you?
We have a good website that has all the information on the services that we provide. And also anyone can just fill the form. Again, filling the form doesn't create any attorney-client relationship. Every case is unique, so we always encourage to reach us out. You can either fill the form or send a direct email with your situation, and then we can schedule a call or a Zoom call and go over your particular case and see how we can help you in your ancillary probate process.
Fantastic. Everybody, this has been Affluence and Advocacy, New York Real Estate Law with Natalia Shishodia. You can learn more at shishodia.com and on social media. Natalia, thanks so much for your time today.
Thank you, Matt.